Please be seated.
The sitting is open. Before we start our judicial proceedings today, I would first like to pay solemn tribute to the memory of Judge
Stephen Schwebel, our esteemed former colleague, who sadly passed away on the 9th of April. The late Judge Schwebel was a member of the court from 1981 until 2000, and he was elected by his peers as Vice President from 1994 to 1996, and as President from 1997 to 2000. Born in 1929 in New York, Judge Schwebel received a BA with highest honors in government from Harvard University, and then chose to focus his studies on international law, first at Cambridge University, and then at Yale Law School, where he received an LLB. During his long and illustrious professional life, Judge Schwebel combined legal careers as a practitioner, an academic, a legal advisor to his government, a judge, and arbitrator. In 1959, he was appointed assistant professor at Harvard Law School, where he founded
what later became the JESAP competition, where hundreds of universities around the planet participate every year. He then became the Bering Professor of International Law at Johns Hopkins School of Advanced International Studies. In the 1960s and 70s, he served as the U.S.
State Department in various capacities, including as Assistant Legal Advisor and Deputy Legal Advisor. In parallel, from 1977 to 1981, he was a member of the International Law Commission. Judge Schwebel thus arrived at the Peace Palace in 1981 with a wealth of valuable experience, which he translated into a rigorous intellectual approach to the court's judicial deliberations, without ever overlooking the importance of maintaining a grounded appreciation of the practical effects of the court's rulings. By his own account, he had followed the creation and development of the United Nations with great enthusiasm, and thus relished the opportunity to put himself at the service of the principal judicial organ of the United Nations. During his 2 mandates, Judge Schwebel was extremely active in the judicial work of the court, in particular overseeing plenary meetings and drafting committee sessions in his capacity as president. As a judge, he was involved in the adjudication of 38 cases, covering a range of complex and often profoundly far-reaching questions of international law. While he fervently believed that the strengths of the court lay in the collective nature of its deliberations, Judge Schwebel nonetheless remained a fiercely independent thinker. It was not uncommon for him to dissent from the majority view, and his persuasively crafted opinions and declarations continue to provide much food for thought for students, scholars, and practitioners. Judge Schwebel left an indelible mark in terms of the general administration of the court, thanks to various significant innovations he launched to improve the working condition of the institution. In that regard, in the 1990s, he was instrumental in negotiating with the host country an extension to the judges' wing of the Peace Palace in order to accommodate the increased number of ad hoc judges and to create a dining facility for judges for the first time. Just prior to his departure from the court, he also spearheaded the initiative
to establish the university trainee program with the New York University, which later became the Judicial Fellowship Program and now involves recent law graduates from all over the world. Following his retirement from the court, Judge Schwebel channeled his indefatigable energy into international arbitration work. During the 2000s, he served as an arbitrator in various cases administered by the Permanent Court of Arbitration. He was also appointed as an arbitrator on various exit panels dealing with investment disputes, and was a member of the Administrative Tribunal of the World Bank. In addition, he published widely on many topics of international law and was the recipient of numerous prestigious awards and honors. Throughout his life, Judge Schwebel dedicated himself to international law and justice with unwavering commitment and integrity. He will be remembered as an exemplary judge who was greatly respected by his peers for his brilliant legal mind and his charming disposition. We extend our deepest sympathy to his family at this sad time. I would now like to invite you to stand and observe a minute's silence in memory of Judge Stefan Schwebel. Thank you very much. Please be seated. I shall now turn to the judicial proceedings before the court. The court meets today and in the coming days to hear the oral arguments of the parties on the merits in the case concerning the arbitral award of the 3rd October 1899, Guyana versus Venezuela. For reasons duly made known to me, Judge Bandari is unable to participate in these proceedings, and Judge Abraham is unable to sit with us today. I note that in addition to interpretation from and into the court's two official languages, English and French, interpretation from and into Spanish is available in accordance with the specific arrangement made at the request of Venezuela. Since the court included upon the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc to sit in the case. Guyana first chose Ms. Hilary Charlesworth. Following Ms. Charlesworth's election as a member of the court, Guyana chose Mr. Rudiger Wolfram. Judge Charlesworth subsequently indicated that, in the circumstances, she had decided no longer to take part in the decision of the case. Venezuela chose Mr. Philippe Couvreur to sit as a judge ad hoc in the case. Mr. Wolfram and Mr. Couvreur were duly installed as judges ad hoc on the 17th of November 2022, during the phase of the present case that was devoted to the preliminary objections raised by Venezuela. I shall now recall the principal steps in the procedure in the present case. On the 29th of March 2018, Guyana filed in the registry of the court an application instituting proceedings against Venezuela with respect to a dispute concerning, I quote, the legal validity and binding effect of the award regarding the boundary between the colony of British Guyana and the United States of Venezuela of the 3rd October 1899. End of quote. to which I shall refer as the 1899 Award, or the award. To found the jurisdiction of the Court, Guyana invoked Article 36, Paragraph 1 of the Statute of the Court and Article 4, Paragraph 2 of the Agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on the 17th of February 1966, to which I shall refer as the Geneva Agreement. Pursuant to Article 4, Paragraph 2 of the Geneva Agreement, the Secretary General of the United Nations decided on the 30th of January 2018 to choose judicial settlement by the Court as the means of settlement of the controversy. By an order of the 19th of June 2018, having been informed that the Venezuelan government considered that the Court manifestly lacked jurisdiction and that Venezuela had decided not to take part in the proceedings, the Court decided that it was necessary, first of all, to resolve the question of its jurisdiction. Following the filing of a memorial by Guyana on the question of jurisdiction and the submission by Venezuela of a document titled Memorandum of Bolivian Republic Venezuela on the application filed before the International Court of Justice by the Cooperative Republic of Guyana on March 29, 2018, a public hearing was held on the 30th of June 2020 on the question of jurisdiction, in which Venezuela did not participate. In its judgment of the 18th of December 2020, the Court found that it had jurisdiction to entertain the application filed by Guyana, insofar as it concerns the validity of the 1899 award and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela. By an order of the 8th of March 2021, the Court fixed the 8th of March 2022 and 8th of March 2023 as the respective time limits for the filing of a memorial by Guyana and counter-memorial by Venezuela on the merits. Guyana filed its memorial within the time limit thus fixed. On the 7th of June 2022, Venezuela raised preliminary objections to the admissibility of the application with reference to Article 79 bis of the Rules of Court. Consequently, by an order of the 13th of June 2022, the Court fixed the 7th of October 2022 as the time limit within which Guyana could present a written statement of its observations and submissions on the preliminary objections raised by Venezuela. Guyana filed its written statement on the 22nd of July 2022. Hearings on Venezuela's preliminary objections were held from the 17th to 22nd November 2022. By a judgment dated the 6th of April 2023, the Court, which understood Venezuela to be making in substance only a single preliminary objection, rejected that objection and found that it could adjudicate upon the merits of the claims of Guyana insofar as they fell within the scope of its competence according to the 2020 judgment. By an order of the 6th of April 2023, the Court fixed the 8th of April 2024 as the new time limit for the filing of the counter-memorial of Venezuela. On the 30th of October 2023, Guyana filed a request for the indication of provisional measures. By an order of the 1st of December 2023, the Court, having heard the parties, indicated two provisional measures, one addressed to Venezuela and the other addressed to both parties. On the 8th of April 2024, Venezuela filed its counter-memorial within the time limit fixed by the court. By an order of the 14th of June 2024, the court authorized the submission of a reply by Guyana and a rejoinder by Venezuela, and fixed the 9th of December 2024 and the 11th of August 2025 as the respective time limits for the filing of those written pleadings. The reply was filed within the time limit prescribed. On the 6th of March 2025, Guyana filed a new request for the indication of provisional measures. By an order of the 1st of May 2025, the court, having heard the parties by means of a written procedure, reaffirmed the provisional measures indicated in its order of the 1st of December 2023 and indicated an additional provisional measure addressed to Venezuela. On the 11th of August 2025, Venezuela filed its rejoinder within the time limit fixed by the court, and the case thus became ready for hearing on the merits of the case. Pursuant to Article 53, Paragraph 2 of its rules, the court decided, after consulting the parties, that copies of the written pleadings and documents annexed would be made accessible to the public on the opening of the oral proceedings. Further, in accordance with the court's practice, these pleadings and documents annexed will be placed on the court's website from today. I would now like to welcome the eminent representatives of the Guyana and Venezuela who are in the Great Hall of Justice today. In particular, I note the presence of His Excellency Honorable Hugh Hilton Todd, Minister of Foreign Affairs and International Cooperation of Guyana, His Excellency Mr. Juan Eduardo Pinto, Minister of Foreign Affairs of the Bolivian Republic of Venezuela, as well as the agent of Guyana and the agent of Venezuela, each accompanied by members of their respective states' delegation. In accordance with the arrangement on the organization of the proceedings, which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round of oral argument will begin today with the statements of Guyana and will close on the afternoon of Wednesday, the 6th of May, 2026, following Venezuela's first round of oral pleading. Each party has been allocated 2 sessions of 3 hours for the first round. The second round of oral argument will begin on the afternoon of Friday, the 8th of May, 2026, and conclude on the afternoon of Monday, the 11th of May, 2026. Each party will have a maximum of 3 hours to present its reply. In this first sitting, Guyana may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by my introductory remarks. I shall now give the floor to the Minister of Foreign Affairs of Guyana, His Excellency Honorable Hugh Hilton Todd. You have the floor, sir.
Mr. President, members of the court,
it is a singular honor to appear before you today on behalf of my country, the Cooperative Republic of Guyana. To open the proceedings in this matter is both a privilege and a solemn responsibility. This case has an existential quality for Guyana. At stake is more than 70% of our sovereign territory, which has been recognized to be an integral part of the country for more than 126 years, including the past 60 years since independence. The Essequibo, as this land is known in Guyana, is named for the Essequibo River, the largest and most remarkable in Guyana, which runs through it. For the Guyanese people, it is tragic even to think about having our country dismembered by stripping from us a vast majority of our land, together with its people, its history, its traditions and customs, its resources and precious ecology. Guyana would no longer be Guyana without it, without them. It is for this reason, and because we are convinced of our right and entitlement to the territory under international law, and in the fairness and scrupulous integrity of this court, that the President of Guyana, His Excellency President Mohamed Irfan Ali, has asked me, as Minister of Foreign Affairs and International Cooperation, to lead Guyana's delegation and to deliver the opening remarks. In Guyana's view, it is appropriate here in these circumstances to underscore the existential nature of this case for Guyana and the Guyanese people. Mr. President, members of the court, Guyana respectfully submits that this case is as straightforward as it is consequential. It is about title to territory. Almost 160,000 square kilometers of territory. That territory was recognized to be part of British Guyana, then a colony of Great Britain, by the award of a unanimous arbitral tribunal, consisting of 5 of the most eminent and highly respected jurists of that era, in October 1899. That award was a culmination of an exhaustive legal process which involved the submission of more than 5,000 pages of written arguments and documentary evidence, followed by a hearing that lasted more than 3 months, and which involved more than 200 hours of oral submissions by distinguished legal counsel and 54 sessions of 4 hours each. All of this was in conformity with the terms of the prior written compromise, executed in the form of a treaty, the Treaty of Washington, in 1897. The case is also about Venezuela's total and unreserved acceptance of that award, not least by the agreement of 1905, which faithfully implemented the boundary determined by the tribunal. For 6 decades, Venezuela fully respected and complied with that award and that agreement. Throughout that period, it never protested or challenged the award or the agreement. In fact, established and uncontested that Venezuela consistently respected the award and the agreement in practice, and that the boundary established by the award and the agreement were consistently reflected in Venezuela's official acts, maps, legislation, and international agreements until at least 1962. Mr. President, members of the court, it is Guyana's submission that the 1899 award is without question legally valid and binding on the parties, and that the 1905 boundary agreement is legally valid and binding on the parties. It is Guyana's submission that none of the arguments Venezuela has raised prior and during these proceedings against the award or the agreement has any merit whatsoever, and that Venezuela's challenges to the award and the agreement are in any event decades, no, a century too late to be raised as a matter of international law. The inevitable consequence is that the international boundary described in the 1899 award and demarcated in the 1905 agreement is, in fact, and has for more than a century been the lawful border between Guyana and Venezuela. Venezuela is obligated under international law to accept and respect that border and to refrain from any activities that infringe on the territory across that border, which constitutes Guyana's sovereign territory. This is a historic moment. This is a moment of truth for Guyana and for Venezuela. For more than 8 years have passed since Guyana filed its application commencing these proceedings. We have now arrived at the final stage. The oral hearings on the merits, after which the court will deliberate and issue its judgment on the validity of the 1899 award and the course of the international boundary between Guyana and Venezuela. We have arrived at this historic moment, despite Venezuela's persistent efforts to stop us from getting here. First, it objected to the court's jurisdiction based on a strained and untenable reading of the 1966 Geneva Agreement, which the court soundly rejected in its judgment of 18 December 2020. Then it objected to the admissibility of Guyana's claims. The court again resolutely rejected this effort in its judgment of 6th of April 2023. Unable to derail the case, Venezuela decided to take matters into its own hands. In late 2023, it purported to stage a so-called national referendum seeking popular support for rejecting the jurisdiction of the court and disassociating itself in advance from any judgment the court might issue on the merits of the case. The referendum called for the endorsement of Venezuela's assertion of sovereignty over the Essequibo and planned to formally incorporate it into Venezuela. On 1st of December 2023, the court, acting on Guyana's request, indicated provisional measures prohibiting Venezuela from taking any of these steps pending the final judgment in the case. Venezuela proceeded to do exactly what the court ordered it not to do. It issued executive decrees, followed by national legislation rejecting the court's jurisdiction, including any judgment that might be forthcoming, and formally incorporating the Essequibo into Venezuela. Last year, after Venezuela announced that it would hold elections in Essequibo to choose a governor and legislative assembly for the territory, the court issued another provisional measures order prohibiting that intended activity. Mr. President, members of the court, Guyana is extremely grateful for the actions the court has taken thus far. Upholding its jurisdiction for Guyana's application, upholding the admissibility of Guyana's claims, and issuing provisional measures orders to preserve the rights claimed by Guyana that are at issue in this case. We know that these rulings were based on the court's faithful application of international law, nothing more and nothing less, but we are grateful nonetheless. Notwithstanding these actions, Guyana has suffered and continues to suffer greatly from Venezuela's unlawful claim to threats to the majority of our territory. This has been a blight on our existence as a sovereign state from the very beginning of our existence. It has been a threat to our peace and security, exacerbated in recent years by the ominous growth of Venezuela's military activities, construction of new bases, new airfields, and its deployment of aircraft, heavy weapons, and troops to the border area. Venezuela's intentions are unmistakable, as revealed in the executive decrees and national legislation to which I referred, the acquisition of our territory and its incorporation into Venezuela. Facing a larger and more powerful neighbor's designs on our territory has not only threatened our peace and security, it has held back our development. To be sure, the international community supports Guyana's sovereignty and territorial integrity, including its title to all of the territory east of the international boundary, as defined in the 1899 award and the 1905 agreement. But economic development has been slowed by Venezuela's claims and its threats. Foreign investors in particular have been reluctant to risk their capital in such circumstances, and far too little investment
has been the consequence. For Guyana, which acceded to the 1966 Geneva Agreement upon its independence, it has taken 60 years to reach this climatic moment and to be in a position to obtain a final, definitive, and binding judgment from the world's most highest judicial authority on the validity and permanence of the 1899 Arbitral Award and the boundary that it established. My predecessors scrupulously followed the processes mandated by the 1966 agreement and exhausted all of them, until in January 2018, the Secretary General, acting pursuant to his authority under Article 4.2 of the agreement, decided that the controversy over the validity of the 1899 award should be resolved by this honorable court. Sadly, not all of the Guyanese statesmen and stateswomen who were instrumental in bringing us to this point have survived to bear witness. As a Guyanese and as head of our delegation, I would be remiss if I did not honor two of them this morning. First, our first agent was a truly towering figure, internationally as well as in Guyana. Our friend and mentor, Sir Sridhar Ramphal. After serving as Foreign Minister and Attorney General of Guyana, became the Secretary General of the Commonwealth, where, among other contributions, he worked long and hard for the freedom of Nelson Mandela. Less well known to you, but equally beloved in Guyana and the diplomatic community that she enriched, Ambassador Elizabeth Harper. The heart and soul of the Guyana's delegations to the court in earlier oral proceedings sadly passed away in September 2025. It is in their honor, as well as in the name of the entire Guyanese people, of past, present, and the future generations, that we carry on this struggle for Guyana's sovereignty and territorial integrity based on the rule of international law. Mr. President, members of the court, Guyana is privileged to be represented by a team of highly experienced and outstanding international lawyers, from whom you will hear today and again on Friday. Our next speaker who will follow me to the podium is Professor Pierre D'Argent. He will respond to Venezuela's ongoing objections to the court's jurisdiction, which consume more than half of its rejoinder, its final written pleading, and which Professor D'Argent will demonstrate and reflect a gross misleading and misinterpretation of the 1966 Geneva Agreement. We will then turn to from jurisdiction to the merits. To introduce that part of the case, two of my fellow Guyanese will make brief presentations. First, Ambassador Donna Street of the Foreign Ministry will introduce you to the territory that underlies this controversy, focusing on its geography and its human and natural resources. And then Guyana's agent, Mr. Carl Greenidge, a former Minister of Foreign Affairs, will speak on the history of the territory and the dispute between Great Britain and Venezuela, leading to the 1897 treaty that provided for arbitration of the territorial dispute between the two states. Mr. Greenidge will be followed by Mr. Paul Reichler, who will address you on the 1897 treaty itself. Venezuela claims that the 1899 award is invalid based inter alia on the invalidity of the 1897 treaty. Mr. Reichler will demonstrate that Venezuela's arguments have no merit, and that the 1897 treaty was a valid treaty and agreement to arbitrate the territorial dispute. In the afternoon session, Professor Alain Pellet will address and refute Venezuela's other arguments challenging the lawfulness of the 1899 Arbitral Award. He will be followed by Professor Nilofer Oral, who will describe Venezuela's acceptance, respect, and the compliance with the 1899 award, as well as its failure to protest for over 60 years and the legal consequences to be drawn from such acquiescence. Professor Philip Sands, King's Counsel, who will demonstrate that the so-called Malay Proverb memorandum, which appeared in 1949 and 13 years later, Venezuela invoked as grounds for nullifying the 1899 award, provides no basis for calling the award into question on any grounds. Guyana's final speaker will be Mr. Edward Craven, King's Counsel, who will address Guyana's breaches to the court's 2 orders on provisional measures and Guyana's submissions regarding the validity of the 1899 award. In closing, I would like to emphasize that Guyana places its fullest confidence in this court, with no doubt that whatever the court ultimately decides, it will be a fair and just result, based entirely on the evidence before it and the even-handed application of international law. As we have done previously, Guyana reiterates its pledge to honor and comply with the court's judgment, whatever it may be, as it is bound to do in any event by the United Nations Charter and the statute of the court. Guyana hopes that Venezuela would make the same pledge. Mr. President, members of the court, I thank you for giving me the honor to appear before you and for your generous indulgence in listening to my remarks. I ask you to please invite Professor Darjean to the podium.
I thank His Excellency for his statement. Je donne maintenant la parole au professeur Pierre Darjean. Monsieur.
I now give the floor to Professor Pierre Darjean. Sir, you have the floor. Thank you, President, members of the court. It's an honor for me to take the floor before you this morning on behalf of the Cooperative Republic of Guyana. As you have no doubt observed, and as His Excellency, the Minister of Foreign Affairs, has just explained, over half of Venezuela's rejoinder focuses on the Geneva Agreement. Venezuela contends that, in view of its content and effect, but in a way which remains largely unexplained, the Geneva Agreement would render moot the jurisdiction which the court declared it possessed in its 2020 judgment, and which it also declared it was able to exercise in the 2023 judgment. These arguments are not new in any way and have already been rejected by the court. However, because Venezuela's pleadings are lengthy, pointlessly controversial and confusing, Guyana deemed it necessary to answer them briefly. This is my task in view of your judgments, which have res judicata effect and which Venezuela persists in defying in disregard of its obligations under the Charter and Statute. As the court's composition has greatly changed since the judgment of the 18th of December 2020, Venezuela is maybe thinking, and very strangely, that it has nothing to lose. The attempt is to no avail, in addition to being devoid of legal merit. The composition of the court, nonetheless, for me, is a reason to ask for your indulgence for a pleading which in reality is not called for. Mr. President, before answering the arguments put forward by Venezuela in its rejoinder, We need to dwell a moment on the underlying reasons which explain why, although it finally has an opportunity to secure a victory for its legal arguments before the court, the respondent is doing everything in trying to avoid it making a pronouncement. This paradoxical situation can simply be explained by the trap which Venezuela set for itself and in which it has been trapped for over 60 years. Presenting the Geneva Agreement to the National Congress in March 1966, the Venezuelan Minister of Foreign Affairs had stressed, indeed, that this agreement would require Venezuela to put all its strength into action to consolidate its claim with serious and detailed studies. The exhortation made by the Minister Iribarren Borges is no doubt the most striking acknowledgement that the claim of invalidity of the 1899 award was made without any serious and detailed studies. This claim of invalidity was thus made instinctively, emotionally, and thoughtlessly, except with regard to its timing, when Guyana's independence was in view. As my colleagues will demonstrate, during the 60 years which have lapsed since the Geneva Agreement, Venezuela has failed to find a more solid basis for its claim. However, once filed and conveyed to all echelons of society, this claim has become an article of faith, which no Venezuelan politician can repudiate without immediately being seen as a traitor to their country. After so many years, what counts now for Venezuela is, as the heading of its written statements shows, for its truth to survive and not to be contradicted by a judgment of the court laying bare this ill-founded and misleading narrative. Yet, members of the court, yet, in substance, this is the task that falls to you. Venezuela's arguments regarding the Geneva Agreement are therefore merely intended once again to postpone this moment of truth. After 60 years, this moment, however, has arrived, and nothing which the court has already said with regard to its jurisdiction and its exercise can be called into question by these arguments. Mr. President, for the clarity of the debates, I would like to deal with Venezuela's arguments following the order in which they're presented in the rejoinder itself. I'll start, therefore, by explaining that Guyana was well-founded in not dwelling in detail on the Geneva Agreement in its reply. After that, I shall show that the interpretation of the Geneva Agreement presented by Venezuela is erroneous and has already been adjudicated as such by the court. I will then examine the argument relating to decolonization and the argument on legal novation recently introduced by Venezuela. These arguments don't add anything to the debate, but well understood, and as I will demonstrate, they allow in reality to substantiate and not disprove the conclusions which the court reached in 2020 and 23, and which, and this will be my last point, which in all respects are res judicata for the parties and for the court. Mr. President, in the first chapter of its rejoinder, Venezuela blames Guyana of deliberately ignoring the Geneva Agreement in its reply. The reproach, of course, is uncalled for, inasmuch as the reply dwells on the merits, and it was submitted after the judgments of 2020 and 2023. In its 2018 memorial on questions of jurisdiction, Guyana explained its position on the Geneva Agreement, and once again, during the hearings of June 2020, which Venezuela decided not to take part in, and which resulted in the judgment of the 18th of December 2020. And yet again, during the phase relating to the preliminary objection raised by Venezuela in June 2022, the written and oral communications of the parties focused once again on the Geneva Agreement, just like the judgment of the 6th of April itself. And it's because Venezuela does not accept the judgments of 2020 and 2023 that it is accusing Guyana of not dwelling on the Geneva Agreement in its reply, although its meaning and scope were considered and determined in those judgments. The first chapter of the rejoinder is therefore an opportunity for Venezuela to try to convince the court that the Geneva Agreement allegedly is not what it very clearly said it was. And I would like to read out paragraph 66 of your 2020 judgment. The controversy that the parties agreed to settle through the mechanism established under the Geneva Agreement concerns the question of the validity of the 1899 award, as well as its legal implications for the boundary line between Guyana and Venezuela. End of quote. Yet the rejoinder maintains that the Geneva Agreement is purportedly, and I quote, much more than a mere procedural stepping stone. It is a substantive instrument designed to address a specific controversy and to provide a path towards a mutually acceptable practical solution. According to Venezuela, the Geneva Agreement purportedly settled the question of the award's validity, so that this question has become moot and therefore cannot be decided, with the consequence that the court would have no part to play because a mutually acceptable practical solution presupposes the agreement of the parties, whereas a judgment adjudicating in one way or another on the validity of the award would purportedly lead to a situation of imbalance between the parties. Mr. President, members of the court, it is clearly striking to observe that whilst claiming to seek a mutually acceptable and negotiated solution for a dispute which wouldn't be the one identified by the court, Venezuela in reality considers, as it already did in 1965 and continued to do so ne variator since then, that the only acceptable solution to its eyes is the one which would grant it what it deems to be its rights over the whole of the Essequibo region. Thus, it's no doubt because Venezuela is seeking a mutually acceptable solution through a negotiation that it unilaterally and illegally sought to annex the whole of the Essequibo at the end of a referendum and elections, which were the subject of orders indicating provisional measures. Through its unilateral contact and the fait accompli which it is seeking to impose in breach of the court's orders, we shall observe that Venezuela is contradicting its own understanding of the Geneva Agreement, a sign, no doubt, that its commitment to the latter, which it never fails to proclaim, is purely a formality and fictitious. The blame levelled against Guyana in the first chapter of the rejoinder therefore amounts to mere posturing and should not be heeded by the court in any way. However, Mr. President, it's in the first chapter of the rejoinder in paragraph 139 that we find the only attempt by Venezuela to explain how the court might decide not to exercise its jurisdiction, established nonetheless in the 2020 judgment, and to rule on the validity of the award. According to Venezuela, the preservation of the court's judicial function is at stake. similarly to what was decided in the Northern Cameroon case, although the two cases are very different. Indeed, in 1963, the court decided not to exercise its jurisdiction, as any judicial decision on the merits would be irrelevant, because, as Cameroon had acknowledged, a court's judgment could not have an effect on a General Assembly decision attaching Northern Cameroon to Nigeria in accordance with the results of the plebiscite supervised by the United Nations. Conversely, and in the instant case, a judicial decision deciding the question of the validity of the award would not fail to have a legal effect, to have some practical consequence on the very object of the dispute. To quote the court in the Northern Cameroon case, your future judgment will remove uncertainty from their legal relations. Now, of course, in the logic of Venezuela, such a decision is not allowed because the Geneva Agreement purportedly pursues another object. But once again, that is not what was decided by the court in 2020, such that relying on the Northern Cameroon case is erroneous because it presupposes what it is attempting to obtain and what the court has already rejected. The first chapter of the rejoinder ends with a barely veiled threat towards the court, and I would like to quote the original in English. The court has no role to play in resolving the territorial dispute over the Guyana Essequiba. Any other approach would exacerbate the dispute. Mr. President, members of the court, it is difficult to read these words other than seeing them as a form of intimidation, as Venezuela is thus announcing in substance and shamelessly that it would itself exacerbate the dispute if it were decided by the court. Guyana does not doubt that the court will not be impressed by this argument and that, faithful to its task, it will decide the dispute, which is it has correctly identified, and it will maintain its jurisdiction. Mr. President, members of the court, the second chapter of the rejoinder, in fact, was intended to replace the 1899 arbitral award on which they held fundamentally divergent and irreconcilable positions with a new practical settlement, regardless of the award's legal status. Throughout its arguments, Venezuela thus claims, in essence, that through the Geneva Agreement, the United Kingdom and Guyana, failing an explicit recognition of the invalidity of the award, would have accepted to relinquish to its benefit, thereby seeking a mutually negotiated acceptable solution. Now, this attempt to rewrite the Geneva Agreement, whilst claiming it, is profoundly erroneous and totally at odds with the judgment for which the court has declared its jurisdiction. Indeed, the court has already adjudicated on this and rejected Venezuela's assertion, according to which the question of the validity of the 1899 award is not part of the controversy under the Geneva Agreement. This instrument, having purportedly been adopted based on the principle that the award is invalid and could not be discussed between the parties. As the court observed, the United Kingdom and Guyana have always considered that the assertion according to which the award was invalid was not justified, and that they accepted the Geneva Agreement only because it preserved the parties' positions in that respect. Looking at jurisdiction ratione materiae and confirming that the object of the dispute had been agreed according to the Geneva Agreement, the question of the validity of the 1899 award, as well as its legal implications for the boundary line between Guyana and Venezuela, the court underscored by using the expression the Venezuelan condition contention, expressed that the disagreement subsisted between the parties, and that solutions had to be sought according to the mechanism agreed in the agreement. As the court expressly stated, I quote, "This in no way implies that the United Kingdom or Guyana accepted the contention before or after the conclusion of the Geneva Agreement." Thus, the 2020 judgment adjudicated that the material jurisdiction of the court extended to the issue of the validity of the arbitral award, this question not having been made irrelevant nor replaced by the Geneva Agreement, and constituted, as the court pointed out, a necessary precondition for any final settlement of the boundary dispute. The court also stressed that Venezuela's argument that the Geneva Agreement does not cover the question of the validity of the 1899 award is contradicted by the statement of the Minister for Foreign Affairs of Venezuela before the Venezuelan National Congress shortly after the conclusion of the Geneva Agreement.
The court also pointed out in particular that the minister had declared that if the nullity of the award of 1899, be it through agreement between the concerned parties or through a decision by any competent international authority, as per agreement, is declared, then the question will go back to its original state. In addition to this, the ministerial address of 1966 clearly manifested at two other occasions, mentioned the purported nullity which was the reason of the dispute with Venezuela, and that it should be settled and established through the Geneva Agreement. On the other hand, the minister believed that with the nullity of the award, Venezuela must consider out of question those territories, and on the other hand, express an opinion on the subject of Venezuelan territory likely to be claimed if the nullity of the award is declared. It is therefore beyond doubt that the question of the validity of the 1899 award was central to the controversy that needed to be resolved, to quote the 2020 judgment of this court. The arguments presented in the rejoinder were therefore already considered and rejected by the court, and it was certainly not necessary to examine them once again. May I note that, indeed, no judge, having voted against the first point of the dispositif of the 2020 judgment, considered that the question of the validity of the award had been set aside by the Geneva Agreement and therefore didn't fall within the scope of the dispute that they were intended to settle. Mr. President, the conclusion of the third chapter of the rejoinder argues, and I quote, that the Geneva Agreement, therefore, must be understood as a crucial step of decolonization, demonstrating a commitment to address colonial-era grievances and to seek a just and equitable solution to a territorial controversy that stemmed from the imbalances of the colonial period. Unquote. Venezuela further contends that even assuming that the award be valid, and I'm quoting the rejoinder in its English version, its territorial consequences could not be applied in absolute and unconditional terms in a dispute where the law of decolonization is the governing legal framework. Guyana does not dispute the existence of well-established principles of the law of decolonization highlighted in Venezuela's rejoinder, nor does it deny the numerous injustices stemming, even today, around the world from colonization and decolonization. However, it is doubtful that a state having declared its independence in 1811, a founding member of the UN, and that has never been a non-autonomous territory within the meaning of the Charter, that this state can be regarded as the subject and the beneficiary of the law of decolonization. Indeed, this law was developed in the second half of the 20th century. Resolution 1514 of 14 December 1960 representing, as the court said, a defining moment in this regard. The law of decolonization was intended to free the then colonized people from colonial power, including colonial rule, including British Guyana. In any case, it is difficult to see what Venezuela is getting at by invoking the law of decolonization. If the point is to argue that the Washington Treaty or the arbitral awards are invalid because they resulted from coercion from a colonial power against a state that had been independent for almost 90 years and benefiting from the support of the largest power of the continent, Venezuela must prove this and not merely assert it. In its written statements, Guyana has already responded to these fallacious arguments belatedly put forward by Venezuela that it had been coerced into accepting the 1897 treaty. My colleague and friend, Mr. Reichler, will return to this point later on. Furthermore, if we are to argue, as Venezuela seems to do in the excerpt of the rejoinder that I just read in English, if we were to argue that Guyana was not entitled to succeed to the UK on the territory delimited by the award, even though it was valid, Venezuela would then have to provide proof of the existence of such an exception to one of the fundamental principles of the law of decolonization that the court only recently recalled. In such an unlikely legal assumption, or even if the award were to be null and void, it would also be up to Venezuela to prove that the boundary agreed in the 1905 treaty that confirmed the demarcation that was decided by the award had not acquired the permanence which the treaty itself does not necessarily enjoy. Instead of basing its claims on a rigorous legal analysis that specifically addresses the obstacles posed by international law, Venezuela merely invoked in a very general and opportunistic manner the law of decolonization, even though this is of no help to it, and that the true beneficiary of this law is Guyana, which was freed from colonial yoke in 1966. As to the rest, Guyana considers that the Geneva Agreement is a remarkable instrument of decolonization because it demonstrates the colonial power's acceptance of the possibility of challenging purported colonial injustices, provided that such injustices are duly established under applicable international law. And this is the very essence of the court's jurisdiction to examine the validity of the award. That the respondents should contest this jurisdiction while invoking the principles of decolonization is profoundly paradoxical. But at the same time, it also reveals that the respondent is indeed aware of the lack of legal basis for its claims. Furthermore, and as it appears from the 2023 judgment rejecting the objections based on monetary gold principles raised by Venezuela, colonial powers accepted through the Geneva Agreement that its conduct at the time could serve as a basis for the claim of nullity. Thus, far from putting Venezuela at a disadvantage, the Geneva Agreement, in fact, offered it the possibility to reopen the case of Guyana Essequiba, to quote the words of the Venezuelan president, Raul Leoni, at the time of its conclusion. The Geneva Agreement would become an instrument of decolonization, turning against decolonized Guyana if it had allowed its neighbor to maintain an exorbitant and unfounded claim indefinitely, hanging a sword of Damocles over nearly 3/4 of the territory inherited upon accession of independence. Mr. President, members of the court, the fourth chapter of the rejoinder presents the Geneva Agreement as an instrument of novation, as a novation, a mutually agreed substitution of the previous situation based on colonial domination for a new negotiated framework. According to Venezuela, in concluding the Geneva Agreement, Venezuela, the UK, and the future state of Guyana agreed to a novatory process that precluded any later reliance on the null and void 1899 arbitral award. Under a new scholarly guise, drawing roots from Roman law and backed by decolonization law, the argument of novation resembles the one rejected by the Court in 2020, but reiterated stubbornly in the rejoinder, and is based on the agreement that the Geneva Agreement settled the question of validity of the award once and for all. The argument of novation differs, however, by arguing that the Geneva Agreement would have fully replaced the former legal regime established by the award, and it necessarily presupposes that this regime had established obligations. Indeed, as Venezuela states, transformation constitutes the replacement of one set of obligations with another. The novation is thus the replacement of valid existing obligations with a set of other obligations. However, since Venezuela maintains that the sentence is invalid, its argument of novation is flawed. In fact, this argument presupposes what the respondent rejects. If the sentence is null and void, it cannot give rise to obligations, and if there are no obligations, there is no question of replacing them entirely with a new mandatory regime contained in the Geneva Agreement. The Venezuelan argument of novation, therefore, is afflicted by an insurmountable internal contradiction. If it was serious, the departure point of any argument of novation should accept that the award is valid and does create obligations, because in order to use the Permanent Court of International Justice's words, it is in the nature of a declaratory judgment, the intention of which is to ensure recognition of a situation at law once and for all, and with binding force as between the parties, so that the legal position thus established cannot again be called in question insofar as the legal effects ensuing therefrom are concerned. On that basis, Venezuela would have to demonstrate that the Geneva Agreement contains a consent, unequivocal and unambiguous consent to effect a novation, that is to say, replace a situation, a legal situation established by the award and which is binding, by another binding situation governing the same subject matter. But the Geneva Agreement had no such legal effect whatsoever. The effect of the Geneva Agreement is not to have recognized the nullity of the award, nor to have settled the matter, nor to have by itself replaced the obligations of the award by another legal regime, since it did not establish a new boundary. The sole effect of the Geneva Agreement was to allow a discussion on the subject of the validity of the award, and to have instituted a mechanism for this discussion to lead to a definitive settlement of the dispute arising from Venezuela's claim of nullity, resulting either in the confirmation of the validity of the award and thus the established legal situation through it, or on the declaration of the nullity of the award and therefore a new demarcation of the border between Guyana and Venezuela if the 1905 treaty and the frontier that it agreed were also and distinctly affected by it. In short, the Geneva Agreement cannot reasonably be interpreted as effecting a novation in whatever form. Mr. President, members of the Court, to conclude, I would say that there is no doubt that the first part of Venezuela's rejoinder seeks to challenge your 2020 and 2023 judgments. The respondent, in fact, makes no secret about this, as it rejects them. However, it never directly challenges the principle of res judicata, and it has not filed an application for a review under Article 61 of the statutes, which is the only procedure allowing the principle of res judicata to be challenged. It must be concluded, therefore, that Venezuela has not discovered any new fact of such a nature had it been known as to be a decisive factor on the conclusions reached by the court in its judgments of 2020 and 2023. And in these conditions, these judgments remain res judicata for the parties and the court itself. In the 2020 judgment, by referring to its jurisprudence, the court emphasized that a judgment on jurisdiction as on the merits is final and binding of the parties under Article 59 and 60 of the state statute. Consequently, depriving a litigant of the benefit of a judgment it has already obtained must in general be seen as a breach of the principles governing the legal settlement of disputes. In this case, all the arguments presented in the rejoinder are on points that have already been explicitly settled, either through or through logical implication, and therefore fall under the res judicata effect. The standard utilized by the court to examine a question of jurisdiction at the merits stage is not whether to find if the arguments presented are new or if they recycle previously stated arguments, but if the decision on them would not contradict the finding of jurisdiction made in the earlier judgment. However, it is undeniable that if these contentions were retained, the contentions of the respondent in the reply would, therefore, if upheld, effectively reverse the 2020-2023 judgments. Guyana, therefore, respectfully requests the court not to deprive it of the benefits of those judgments and to proceed with the settlement of the dispute on the validity of the 1899 award. I would like to thank the court for its kind attention, and I would like to request the President to give the floor to Madam Ambassador Ms. Tonnet Street to address the subject of the geographical context of the dispute. Thank you very much.
Je remercie le professeur d'Argent. I now give the floor to Ambassador Tonnet Street. You have the floor, Madam.
Thank you. Mr. President, members of the court, it is my privilege to address the court on the nature of the territory that lies at the very heart of this case, the Essequibo. Before the court turns to the legal questions surrounding the 1899 arbitral award and its validity, Guyana considers it appropriate to set out concretely what is at stake in these proceedings. As the court will see, Venezuela's claim is not directed at some remote frontier land. It is directed at the heart of my country, the vast majority of its sovereign territory, over 70% of it. Let me begin with the sheer scale of what is being claimed. Guyana is the third smallest country by geographic area in South America, comprising no more than 215,000 square kilometers of land. Venezuela, by contrast, is more than 4 times larger. The area claimed by Venezuela comprises all of Guyana's land territory lying to the west of the Essequibo River, after which the region is named. It accounts for almost 3/4 of Guyana's total land territory, a vast expanse of about 159,500 square kilometers. 6 of Guyana's 10 administrative regions are located within it. I respectfully ask the court to pause on this figure. Venezuela is claiming almost 3/4 of Guyana's sovereign territory, the land in which much of Guyana's population lives, where much of its economic activity takes place, and where its most precious natural, ecological, and cultural treasures are found. For a small developing nation, the loss of nearly 3/4 of its territory would not be a border adjustment. It would be the dismemberment, indeed, the effective destruction of the country. I turn now from the size to the character of the territory Venezuela claims, because its significance to Guyana is not only a matter of size, it is a matter of what the land contains and what it means to our Guyanese people. Guyana's name is aptly derived from an Amerindian word, Guyana, meaning the land of many waters. That is because Guyana possesses a vast hydrographic network consisting of 14 major drainage basins. The Essequibo River is by far the longest, extending some 1,014 kilometers, making it one of the largest rivers in South America. Its major tributaries, the Potaro, the Cuyuni, the Mazaruni, and the Rupununi, all flow through the Essequibo region. These rivers are the arteries of our national life. For the people who live in the Essequibo, they are how communities stay connected and communicate and trade with one another. They are the source of fresh water and the lifeblood of ecosystems that support biodiversity and vital carbon sinks for current and future generations. The natural endowment of the Essequibo region includes more than its rivers. The region is also lined by interconnected mountain ranges, including the Pacaraima Mountains. This is where Guyana's highest mountain, Mount Roraima, forms a tripartite boundary among Guyana, Venezuela, and Brazil. In the very center of the Essequibo region lies the Irocrama rainforest, the green heart of Guyana, one of the last 4 untouched tropical rainforests in the world and a site of global ecological significance. This pristine and delicate environment encompasses a vast area that is universally recognized as rich in diverse species of plants, animals, and insects, including many threatened with extinction. It is a sanctuary for conservation, scientific research, and ecotourism. Guyana has designated 371,000 hectares of pristine forest at Irocrama to promote the conservation and the sustainable and equitable use of tropical rainforests. The ecological significance of the Essequibo region is matched by its economic importance. The region is the engine of our economic development. Gold mining in parts of the region dates back to the 19th century. Considerable deposits of bauxite and manganese are also found in the Essequibo region. There is significant potential for the exploitation of oil and natural gas in the waters adjacent to its coast. These natural endowments are essential to Guyana's economic development. The region also supports substantial agricultural activity, from rice cultivation along the low-lying coastal areas to cattle ranching in the upper Essequibo area, which supplies beef for export. I have described our land. Let me now speak of the people, because the Essequibo is not merely territory. It includes the people who inhabit it, who administer it, and who belong to it, including my own family. According to the most recent census conducted in 2022, the Essequibo region has a population of 313,175, more than 1/3 of Guyana's entire population. These include members of 9 indigenous groups, the first inhabitants of this land. The remainder of the population reflects Guyana's rich ethnic and racial diversity, including descendants of Dutch settlers, the first Europeans to occupy the territory, and descendants of Africans and Asians brought to this land as slaves and indentured servants respectively by Dutch and later British colonizers between the 17th and 19th centuries. As Guyana's agent, Mr. Greenwich, will shortly explain, it is a historical fact that there was no Spanish colonization or permanent settlement anywhere in this territory. The Spanish may have been the first Europeans to set their eyes on the vast northern coast of South America, or to claim it, but they never established a presence of any significance there, nor have they ever administered it. As Mr. Greenwich will explain, the British followed the Dutch into the Essequibo region during the first half of the 19th century, forged alliances with the various indigenous communities, explored and mapped the area, and expanded British settlement and administration beyond the coast into the interior. There was never any Spanish or Venezuelan administration there. British administration deepened in the second half of the 19th century and continued until Guyana's independence in May 1966. Since then, Guyana has exercised full sovereignty and governance over the Essequibo region. It administers education through schools across the region. It operates postal services, manages fisheries, enforces environmental regulations, and invests in infrastructure projects. It collects taxes through the Guyana Revenue Authority. Guyana also conducts national and regional elections in the Essequibo region, as it does everywhere in Guyana. In the last elections held on September 1, 2025, 9 members of parliament were elected from geographical constituencies in the Essequibo. These are not abstractions. In exercising their democratic right to vote and choosing their representatives, the people of the Essequibo affirm their commitment to and identification with the sovereign state of Guyana. Mr. President, members of the court, I have sought to show in concrete human and physical terms what the Essequibo region is. It is an integral and essential part of Guyana. Its geography, its economic activity, its culture, and the continuous governance of its land and peoples, first by the Dutch and then by the British, and since 1966 by Guyana itself, are not matters of abstract historical interests. They are the substance of Guyana's national life. They are an indelible feature of Guyana's national and cultural identity, and they are the crucial foundation for Guyana's security and development. Guyana has no designs on anyone else's territory, but we insist on our rights to our own territory, which, by virtue of the arbitral award of 3rd October 1899, includes Essequibo. Guyana's legal team will explain why that award remains legally valid and binding on both Venezuela and Guyana, and why Venezuela's challenges to it should be rejected. I am very grateful for the court's attention, and I ask that you invite Mr. Carl Greenwich to the podium to make Guyana's next presentation. Thank you.
I thank Ambassador Street. I now invite the agent of Guyana, Honorable Carl Greenwich, to address the court. Sir, you have the floor.
Mr. President, members of the court, it is my great privilege to address you this morning, and I will continue Guyana's presentation on the territory in dispute. Ms. Street discussed the land and its people. I will now briefly describe its history as part of a Dutch and then a British colony in the period leading up to the boundary dispute with Venezuela that began in the middle of the 19th century. Mr. Reichler will then carry the story forward through efforts by Great Britain and Venezuela to resolve this dispute with the support of the United States, culminating in 1897 with the execution and ratification of the Treaty of Washington, which enshrined the agreement to submit the dispute to arbitration. The post-Columbian history of our territory begins with the arrival of the Dutch in 1598. They were the first Europeans to establish themselves in what is now Guyana. By 1616, they had founded the colony of Essequibo, erected Fort Kaikoverall along the Mazaruni River, west of the Essequibo, as their seat of government, and begun to settle and administer the territory stretching westward toward the Orinoco. 5 years later, in 1621, the States General granted the Dutch West India Company its charter, by which it took charge of running the colony. In 1744, the seat of Dutch administration was moved to Fort Zeelandia. And the Spanish, they were nowhere to be found, not east of the Orinoco at any rate. Their nearest outpost was San Tome on the banks of the Orinoco. This was the easternmost Spanish settlement. The Spanish governor there was candid about his predicament. The settlement, he wrote, was so far distant from other Spanish possessions, the nearest being Venezuela, more than 650 kilometers away. Later, a settlement at Upata, slightly south of San Tome, was established. Spain never settled any territory farther east of the Orinoco. Spanish attempts to do so were repelled by the Dutch. The reality was enshrined by the Treaty of Munster in 1648. Spain recognized Dutch independence and expressly accepted the territorial status quo on the South American mainland. In 1730, the Treaty of Utrecht reinforced that of 1648, confirming Dutch authority over the territory and settlements it had established in its South American colonies, which then included territory west of the Essequibo River. Over the course of the 18th century, the Dutch moved deeper into the interior of the Essequibo region and further westward along the Atlantic coast. This map, produced in 1748, shows the extent of Dutch settlement and administration of the Essequibo River at that time. The Dutch were then settled along the Pomeroon River, which still bears its original name, as well as Cape Nassau, Moruga, Sprout, Weimar, and Amakura at the mouth of the Orinoco River. The extensive Dutch settlement of this territory during the 17th and 18th centuries is evidenced by the Dutch names maintained to the present day of the villages, towns, rivers, and other geographic features. 35 of these place names are now listed on your screens at tab 4 of your folders, along with their geographical coordinates. In sharp contrast to the widespread Dutch settlement of the territory, lying between the Essequibo and Orinoco rivers, there were no Spanish settlements east of the Orinoco. Venezuela recognizes Dutch presence on the west bank of the Essequibo, but seeks to characterize this as very limited and temporary in nature. That is historically inaccurate and not supported by the evidence. What Venezuela does not say, and what it cannot say, is that there was any Spanish settlement or administration in this territory. By the early 19th century, the Dutch were displaced, but neither by Spain nor by Venezuela. They were displaced by Great Britain. After tensions arose between the two powers, in part because of the Dutch had backed the American colonies in their struggle for independence, Britain seized the Dutch possessions in this area, and in the early 1800s. In 1803, the Netherlands ceded its colonies to Britain under the Articles of Capitulation of Demerara and Essequibo. At the close of the Napoleonic Wars, the Dutch formalized the transfer. The 1814 Convention of London ceded the colonies of Essequibo, Demerara, and Berbice to Britain. The Treaty of Paris of 1850 confirmed it. Only in Suriname in the east was returned to the Dutch. For the first decade and a half after the Treaty of Paris, Britain maintained the separation of Berbice and the Essequibo Demerara. In 1831, King William IV merged them into one to form the colony of Great Britain. The colony of British Guyana. With a newly consolidated colony, Britain set about increasing its understanding of what it possessed. It began by commissioning a survey of the territory, which included an effort to determine its western boundary, that is, where British Guyana ended and the nascent Republic of Venezuela began. Robert Schomburgk was entrusted with this task. Schomburgk, a German-born botanist, surveyor, and geographer of considerable distinction. Between 1835 and 1839, Schomburgk carried out 3 major expeditions into the territory west of the Essequibo under the auspices of the Royal Geographical Society. In the process, he traversed vast swathes of the interior. Venezuela's rejoinder dismisses Schomburgk as a mere Prussian technician who drew boundary lines, different from the one that had been known until then. In fact, until then, there was no known boundary, much less one that was recognized or agreed. The Schomburgk expedition was an effort to establish such a boundary. In 1840, following his earlier excursions through the territory west of the Essequibo River, Great Britain directly commissioned Schomburgk to map out the colony's borders. The intention had been to share the results with Brazil and Venezuela and to inform Venezuela in advance of Schomburgk's mission and its objectives. The Venezuelan president, José Antonio Páez, did not protest. In fact, he welcomed Schomburgk's mission. British colonial records report that President Páez conceived this to be the best opportunity to settle definitively this affair, which interests both nations. He also proposed that the two countries set up a joint commission to conduct the survey, prefatory to concluding a treaty of limits. But by the time the Venezuelan president's message reached London, Schomburgk had already set out on his mission. Between 1841 and 1844, Schomburgk conducted 5 expeditions into the interior, shown on this map. In the first trip, shown on the map as Trip 1, he journeyed along the Barima and Cuyuni rivers and raised British flags and markers at Barima Point on the coast. In his own words, the British Empire acquired, therefore, Guyana, with the same claims to the termini of its boundaries as held by the Dutch before it was ceded by treaty to Great Britain. Of equal importance is the determination of the western boundary of British Guyana, the limits of which have never been completely settled. In this report, Schomburgk documented the chain of Dutch settlements stretching westward to the Barima River and noted that disinterested scholars in the 18th century had uniformly treated the Barima River as the western edge of Dutch territory. He placed the British frontier at the Amakura River, 4 miles west of Barima Point, as is no doubt the most natural limit west of the possessions of the Dutch. The map and boundary line he produced became what is known as the Schomburg Line. It became the basis of British territorial claims in the late 19th century, including that of the arbitration against Venezuela, that resulted in the award of the 3rd of October 1899. The Schomburg Line that the British presented to the arbitral tribunal is shown here highlighted in yellow. The actual British claim line in the arbitration is highlighted in green. Venezuela's reaction. The Schomburg Line triggered consternation in Venezuela, which protested it and asserted its own claim to the territory east of the Orinoco River, extending to the Essequibo River, as shown here, highlighted in red. In asserting this claim, Venezuela did not point to any military bases or to settlements it had built, officials it had posted, or taxes it had collected. It pointed to the heavens, quite literally. Venezuela invoked the papal bull of 1493, issued by Pope Alexander VI, a Spaniard, and declared on that basis that the right of Spain to the territory of America has always been indisputable in the eyes of all nations of the world. The treaties by which Britain inherited the Dutch colonies were, in Venezuela's view, void because the Netherlands had conveyed to England what did not belong to her and what she knew did not belong to her. End of quote. Great Britain rejected Venezuela's claim and continued to promote settlement of the region under its administration within the area encompassed by the Schomburg Line. The British made efforts to reach an understanding with Venezuela on the location of the boundary. Various proposals were exchanged, beginning in the 1840s, but no agreement was reached. In the meantime, British settlement continued to expand westward within the Schomburg Line. Venezuela felt powerless to stop it and grew increasingly desperate in attempting to prevent further British consolidation. Some progress towards a resolution was made in 1850 when Britain and Venezuela exchanged letters in which each undertook not to encroach further on any disputed territory until a final settlement on the boundary was reached. There was a problem with the so-called 1850 agreement, however. It did not define or describe the territory that was disputed, leaving this for each party to determine for itself. Over the course of the following decades, Venezuela repeatedly complained about what it considered Britain's frequent violations of the 1850 agreement, including its extension of control over the disputed territory between the Essequibo and Orinoco rivers. In 1877, Venezuela's minister in London, José Rojas, approached the British Foreign Office with a proposal for an amicable settlement. By 1880, formal negotiations had begun, but no progress was made. In November of 1883, with the prospect of a diplomatic settlement bleak, Venezuela proposed for the first time that the territorial dispute be settled by arbitration, pursuant to which the decision of an arbitrator who freely and unanimously chosen by the two governments would judge and pronounce a sentence of a definite character. Great Britain rejected Venezuela's proposal for arbitration. Undoubtedly, it offered to arbitrate only the territory west of the Schomburg Line, that is on Venezuela's side of the line. This was quite understandably not acceptable to Venezuela. Faced with British intransigence on the scope of the arbitration, on the 20th of February 1887, Venezuela broke off diplomatic relations with Great Britain. In its exasperation with the British, Venezuela turned to the United States for support and assistance, asking the US to use its power and influence to persuade the British to submit to arbitration, title to the entire territory claimed by both Britain and Venezuela, that is, all the land lying between Essequibo and the Orinoco rivers. The history is clear. and established by the evidence before the court. It was Venezuela that insisted on arbitration. It was Venezuela that brought the United States into the picture to help it obtain the arbitration agreement with Great Britain that it was unable to obtain on its own. And ultimately, as Mr. Reichel will show you, with the support of the United States, Venezuela secured the arbitration agreement on which it had been insisting for more than a decade in the form of the 1897 Treaty of Washington. Right up to the president, Venezuela heralded and celebrated the treaty as the accomplishment of its long-sought objective and profusely expressed gratitude to the United States for its indispensable contribution to that end. Venezuela maintained this attitude towards the treaty and its implementation for the next 60 years. It neither questioned, challenged, nor criticized the treaty. In contrast, in these proceedings, Venezuela takes exactly the opposite position. It attacks the very treaty, claiming now that it was unlawful and invalid on several grounds. At this point, I pass the baton to Mr. Reichler and invite you to call him to the bar to show that there is no merit to any of Venezuela's belated and totally unpersuasive challenges to the treaty. Mr. President, members of the court, I thank you for your kind attention, and I ask that you invite Mr. Reichler to the podium, perhaps after a short break.
I thank the agent for his presentation. Before I give the floor to the next speaker, the court will observe a break. The hearing is a break of 10 minutes. The hearing is suspended.